It's really my great pleasure to introduce today our third speaker in our summer series conference, Justice David Stratis of the Federal Court of Appeal. We're really excited to have Justice Stratis. My name is Mark Mancini. For those unfamiliar, I'm the National Director of the Runnymede Society. So in the interest of time and without further ado, I'm going to introduce Justice Stratis, and then we're going to proceed today in a bit of a different format than our past summer speaker series. We're going to proceed in the interview format. So I'm going to ask Justice Stratis some questions. We're definitely going to leave time for questions at the end. You will see that there's a Q&A box on the webinar that you can type in questions. You're free to type in questions at any time, and then at the end, I'll be sure to go through them and try to get to all of them, depending on how many of there are. And before I kick it off, I do want to say, if you have any questions about the Runnymede Society, our programming, what we do, please feel free to contact me. My email address is on the Runnymede Society website. I'd be happy to talk with you about any questions you have. So without further ado, let me introduce our special guest, Justice Stratis. David Stratis has been a judge of the Federal Court of Appeal since 2009. He was educated at Queen's for his LLB and Oxford University for his BCL. He then served as a law clerk to Justice Bertha Wilson at the Supreme Court of Canada. Following that, he practiced law at top Toronto law firms, earning awards and a reputation as a very talented litigator. He continues to serve as an adjunct at Queen's University, and I think it goes without saying he's known as probably, or most, for sure, Canada's best administrative law judge. So we are just pleased to have Justice Stratis here today. He's a wealth of knowledge, and we're all going to learn a lot. So Justice Stratis, thank you so much for joining us today.
It's a real pleasure. Thank you, everyone, for attending this. I hope it will be informative and useful to you.
Fantastic. So we're going to kick it off. Our theme today is opportunities for young lawyers and general updates on how things are going in the courts in terms of access to justice. So let's start maybe with the question, in general, how have courts coped with this new pandemic that we're dealing with? And specifically, what's been happening in the federal court system where you spend most of your time?
Sure. Mark, I think the person who's best to answer your question is actually the Canadian public, the users of court services. Given the general absence of complaint, not a complete absence of complaint, but the general absence of complaint, I think the short answer to your question is that it's gone surprisingly well. You know, the pandemic came as a surprise to everyone, including the courts, and the courts had to adapt and roll with the punches so that we could fulfill our primary mission, which is to serve the Canadian public as best as we can. I think what happened, looking back, is that when the pandemic hit and the situation was especially dynamic and governments were feeling their way and starting to issue orders and regulations and then changing the orders and regulations to ramp them up even more, it was a very dynamic and unpredictable situation. I think the reaction of most courts responsibly was to just suspend everything, put everything in stasis until things were a little more known. And that's certainly what the federal courts did. Initially, there was a complete suspension period, so that time under the rules, orders, and directions didn't run. And we weren't holding hearings. Slowly since that time, as things have been stabilized in the federal court system, we've been holding hearings by Zoom, and we've been allowing certain files to proceed instead of being suspended. Tomorrow, there's going to be a new notice from the court, so any federal Court of Appeal users out there, you'll want to see this notice. But the trend, without giving you advance notice of what's coming, but the trend is definitely going to be for a relaxation of suspension since conditions are getting a little bit better.
That's very interesting. I mean, that everything has been going on Zoom. And one thing I did want to ask you is how you think in general the Zoom hearings have gone since you've been doing them in the time of this pandemic.
Well, a couple things on that. First of all, I'm kind of proud to say, as a federal court of appeal person, the federal courts have always been pretty innovative, and the fact is we have had video conferencing capability and the odd hearing by video conference since the late 80s.
Oh, wow.
So the idea of holding an online hearing was not foreign to us. But certainly the kind of hearing, this sort of hearing over Zoom, and the frequency is much, much higher. In fact, if you look at our federal court's rules, they were amended to allow for a high degree of electronics in our court. And we've been doing a lot of electronics, and I can talk about that more in a moment. But in precise answer to your question, the hearings have been going well. I think, there's the odd technical problem that arises. I was in a hearing very recently where counsel was having trouble with his computer, and so you roll with the punches, right? We gave an adjournment, and it all got sorted out. At one point, the registry was having a little problem, so another little adjournment. We roll with the punches, but I'll say this just to summarize. These hearings online, they're adequate. And all that courts are legally obligated to do is provide an adequate, fair hearing. Online hearings like this discharge that, but I think everyone, courts and litigants alike, would like to go back to in-person hearings when it's responsible and safe to do so.
I think that's an interesting point because I think we rightly or wrongly, we hear more calls to have electronics in our court system. So
I'm skeptical about the hearings.
Yeah, okay.
I'm okay. People know me both within the court and friends. They know me as technologically very savvy, not as savvy as some of the people watching this, but I'm confident enough. But in-person hearings have a high degree of engagement, and I think it's very important from the litigant's perspective that they and their clients see the whites of the judge's eyes and confront very personally the decision maker. There's a sense of speaking truth to power, and through a video screen, good enough.
Right.
But in person, if we have the resources to do it, in person is the best possible hearing we can afford. And we're all about serving the public. So I think most of us, that's how we would like to roll.
Are there, for those that do want more electronics in the courtroom, are there any obstacles that you can foresee to that reality, for us to reach that reality?
Yeah, there are some people in the lawyering community who still don't like electronics, and they tend, in my experience anyway, to be the more senior people who call the shots on files when there's teams of lawyers. And so there's still a bit of reluctance in the community we serve to doing things electronically. I've noticed, though, over the 10.5 years I've been a judge on the court, that things are changing. And maybe it's the retirement more and more of these people. But the electronics, we're getting requests more and more for records to be filed electronically. And more we are acceding to those requests. Judges themselves, I think their service ethic, the ethic of serving the public, means that many are working hard to become confident using electronic materials. I would say, by way of self-criticism of our profession, that we can work harder on that. I would like to see the Canadian Judicial Council, when it revises our ethical principles, to actually make it a professional requirement that judges be fully conversant in and confident in electronics. But electronic materials, again, for a court like ours, we've been using them for a long, long time. We're a traveling court, and we appreciate electronics because we can load publicly filed materials on our iPads and read on planes and that sort of thing. I should mention as well, as a court system, we're pretty innovative. You know, you look at the big pipeline cases that came through, like Northern Gateway, TMX1, TMX2. You know, to look at TMX2, the most recent one about the Trans Mountain Pipeline, it came through the court. It was made, despite its size, complexity, multi-party nature, it was made completely electronic. And as you can imagine, there were lots of motions and other sort of regulatory things that had to happen along the way. All of that was electronic. And it galloped and was, despite its importance and size and complexity, it was made ready within a handful of weeks. Wow. So we have experience using electronics, and we welcome electronics.
Interesting. So let me ask you just a very blunt question. What's the future? We've had a lot of discussion in the Twitter world and in the lawyer community about what the future is for the court system as we know it. Some have proposed radical reform, some have proposed lesser measures. But what do you think the future is, in your view, for this, you mixing electronics with in-person hearings and trying to serve the public, as you said?
Yeah, I think to some extent I've nibbled at this question already.
Yeah.
I think the public we serve would prefer in-person hearings. I know many, particularly in the academic community, think online courts would be wonderful. Maybe in some matters they might be wonderful. It may be, for instance, the idea that people have to show up in person to set criminal dates in criminal court. Maybe that should change, and that could be done online, or if necessary, to speak to an adjournment online. Perhaps reforms can be made there. But for hearings on the merits, I think the public we serve wants their day in court. They want truth to power. They want to see the whites of the judge's eyes. They want the full engagement that an in-person hearing gives. In terms of getting to that in-person hearing, I think we now have not just a green light, but a flashing green light to see filings more and more in electronic form. And so that's where I think initially in most courts we will see the most reform.
So the in-person hearings aren't going away. But we're going to maybe see some supplementation with other sorts of things, other sort of lesser motions, maybe electronically.
Well, I think so. I'm a person that looks to other jurisdictions to see what they're up to, and I was quite surprised. I was curious, and so I sort of rooted around the internet and found our sister court. I'm in the Federal Court of Appeal. Our sister courts are the U.S. Circuit Courts of Appeal. And I was fascinated to see that the D.C. Circuit Court of Appeal, 65% of its matters, 2/3 of its matters, are disposed of without an oral in-person hearing. And that happens to be the most pro in-person hearing court in the entire U.S.
Wow.
Some are as high, Mark, some are as high as 80%.
Oh, wow.
In terms of disposing things on the basis of written materials. I do not see us going that way. Well, as long as our resources remain decent as far as hearings are concerned, I can't see in-person hearings going away anytime soon. People want to confront people. confront the people that are deciding the matter. They want the engagement that an in-person hearing gives. They want to speak truth to power.
And I think on that note, and also on the note of just discussions about what the proper balance is between in-person and reform. You're probably familiar with this, with a speech that was given by Justice Abella, the Supreme Court of Canada at Harvard. And the title of the speech, or that appeared in the Globe and Mail, was "Our Civil Justice System Needs to be Brought into the 21st Century." And just for our audience, because I think it gets to this theme of what kind of reforms are needed and at what level. Justice Abella says, "I have a more fundamental concern. I cannot for the life of me understand why we still resolve civil disputes the way we did more than a century ago." And she goes on to say that it's time to think about designing a whole new way to deliver justice to ordinary people with ordinary disputes and ordinary bank accounts. So I guess on this theme and this debate about how we pitch reform, what do you think about these comments by Justice Abella? Because they were taken by many to mean radical reform of the way we do business as lawyers. So what do you think of the speech in terms of your views on this issue of access to justice?
Yeah, I found the speech interesting and read it with interest. I was disappointed. I think there's some regrettable things in it. First of all, it was a repeat of a speech she gave in 2011. And the fact is, much has happened in the last 9 years. Much has happened. And I would, single out the many reforms done across the country. I've been talking about the federal courts of appeal and the federal court and its innovation. But you can look to other jurisdictions that are ahead of us. The Saskatchewan Court of Appeal has been effectively an electronic court now for 8 years. The BC courts generally, I salute as being incredibly innovative. So in the last 9 years, things have changed, and I don't think the situation that she described in 2011 is the same as today. The other regret that I have, and Justice Bell is not alone on this, many do this, is you can find a lot of things to criticize about in terms of the justice system and how it operates. I have two comments on that. First of all, think of the challenge. Courts have to be all things to all people in a very complex society. This is a really difficult task. But my other source of regret is that it's easy to identify the problems, and we're not stupid. We're all wired to serve the public, and we're painfully aware when we fall short of serving the public against what we would ideally like. The real challenge is solutions.
Yeah.
And here I'd salute one of her former colleagues, Justice Cromwell, who in the later years in the Supreme Court of Canada took on at considerable professional and personal expense. It just took scads of time. But he toured the country and identified problems and developed many ideas about access to justice. So to come up with, a laundry list of problems and, just to broad brush and say arbitration and mediation doesn't work, when in fact, in some situations, not only does it work, it's a really good solution in some contexts, on some occasions.
Right.
The real focus has to be on solutions.
Well, speaking of solutions and this access to justice issue, I think it is important that we get into some detail about things that are happening around the country and specifically in the federal court system about access to justice.
Sure.
So what are sort of some of the initiatives in the federal court system that have been designed to promote access to justice? And what are the solutions that, you're speaking about solutions. What are some of the solutions that the federal courts have used to address the access to justice problem?
Right. I think we're advantaged because we travel in a
Right,
strange
yes.
way. Normally
Yeah.
that would be a challenge and a disadvantage, but we're advantaged because also a lot of our jurisdiction is coordinate with superior courts. So in a sense, we're competing over jurisdiction in areas like copyright and patents. So we have been forced to be sharp on our access to justice game. Some things we've done that I think are very helpful. Unlike some jurisdictions, we have a very small rules committee. It's approximately 20 people, which I think Ontario's gets as high as 50, by example. And it's chosen to do its business by a number of fast and fleet subcommittees. So it doesn't operate as a 20-person chamber of debate. This allows us to react quickly and get things done. Another thing we did, which is really smart, is every 10 years, the Rules Committee forms a blue sky committee, a policy review committee, looking very critically, nothing preordained about what our practices and procedures should look like. I chaired that committee and it reported in 2012, so we're coming up to another blue sky committee soon. And we had many, many recommendations, including electronic courts, and that sort of thing helps to keep us sharp. We have a bench and bar committee that is excellent and keeps us sharp as well. We've developed, I think one access to justice initiative is the fact that 99.9% of our motions are done in writing. And not only does that allow us to deal with motions quickly, because proceedings bog down motions. And if we have to have oral hearings all the time, particularly for a traveling court like us, it would be full of delay. We do it in writing, but what writing allows us to do is to engage in soft case management. So suppose you have an appellant who's unrepresented and they're delaying in terms of producing an appeal book. Well, an appeal book for an unrepresented person is a very challenging thing. I have sometimes written up orders that say, do your appeal book within 45 days and do it in the following way. And sometimes I've actually invoked the image of a kitchen recipe that they must follow. Otherwise, things will go wrong. I put it that way to them sometimes. And then you set out in writing all the steps in detail. And for others, sometimes they're not using the rules, so I give them a link to the rules, or I'll look up on the internet their locality in case they don't have a computer and tell them a local library that will probably have the rules. So that they can begin to try to follow these things. That's what I call soft case management, and doing things in writing on the interlocutory stage allows us to do that. There's other sort of examples. I've talked about the TMX file, the pipeline file, totally electronic. One philosophy there, just to show you the kind of innovative things to ensure access to justice and make things go fast and inexpensively, is in TMX2. I happen to be the case manager. There's a vision of judges that they're just sphinx and blank slates. And so when an issue arises, parties are expected to educate us about absolutely everything. What I like to do is, because I'm not a sphinx and because I know a little law, is sometimes I will issue a direction calling for submissions, and then I will write out my understanding of the law. Now, it sounds like prejudgment, right? It doesn't sound fair. But what I do in the direction, and it's very heartfelt and genuine, is I say, well, that's my understanding of the law. Give me submissions on whether you agree with what I've just said, whether I've overlooked something, whether there are cases I have not mentioned, and make any other submissions that you are relevant, that you feel are relevant to this issue. What that does is it really shortens the time that I need to give for submissions, and it causes counsel to be incredibly focused
Right.
on submissions. They know they don't have to, write long briefs educating me on stuff I already know.
Right.
So that's just an example of innovating, moving away from a traditional view as judges sphinx to judges almost helping the resolution of a dispute,
Right.
while still being procedurally fair.
And I suppose in a case like TMX, the TMX line of cases, it helps the parties to narrow the scope of the issues that are before the court. If they
very much.
Yeah.
Not only does it tell them what I know, thus they don't have to address, but it also tells them up front what I'm wrong about.
Right.
So they can correct me. And they're not shy, and they'll do that. But it causes, for me as the judge, and for the public that wants things decided in the public interest, it allows me to get really high quality, focused, useful submissions. And as we all know, garbage in, garbage out, great stuff in, great stuff out. So I think this is just one sort of thing that judges can do when they think about how they decide cases, to innovate and make the process shorter, better, cheaper, with a better result for the public we serve.
Great. That's great. And I mean, I think the TMX line of cases is an example of this. And I would encourage people to kind of look up uncannily the orders, and to the extent that they're public, and take a look at what the court did in those cases.
The truth is, most are not public.
Okay, yeah.
Over a period of about 8 weeks, there were 79 orders, directions,
wow,
and judgments and reasons. But the big ones are online.
Yeah, yeah.
But again, I want to emphasize that technology allowed me as case manager to receive things quickly, to cause counsel to react quickly, to get useful things in quickly, and to produce quickly back. And a big part of this that we haven't talked about isn't just the judges in a court, it's the support staff.
Yeah.
And in particular, the registry of this court, which I will boast and say is best, most client-focused in the country, from what I hear from lawyers who use the system and unrepresented people. Boy, did they roll with the punches.
Right.
They really got used to working electronically. And it became a situation where counsel would file something electronically, and within 5 minutes, I would know about the filing and could begin work. And that's just compliments to a fantastic registry.
Right. I think the theme of this pandemic has been rolling with the punches.
Yes, sir.
Judges and litigants. And with that I'd like to pivot a little bit now away from the courts and to sort of the subject of today's, one of the subjects of today's talks, which is young people, young lawyers, articling students, law students, who have also had to roll with the punches during these times.
You bet.
So we'll start this theme off by just me kind of asking you, do you have advice for young lawyers, articling students, law students who are dealing with this pandemic, who have the extra challenge of perhaps writing bar exams, who are beginning their careers? What advice would you offer them in this weird, bizarre time?
Yeah, it's weird and bizarre.
Yeah.
I would begin by just giving this big picture advice. Ask yourself what separates human beings from other animals. I'm going to venture a guess that other animals live in only 3 dimensions: height, width, and length. Humans are aware of a 4th dimension, which is time. And unfortunately, sometimes as humans, we forget the 4th dimension and we only react to the moment and to physically what's going on to us, and what I'm tapping myself here, I am feeling that, and I react to that. We're creatures of the moment, living within our physical reality. I encourage everyone to think always of the 4th dimension in everything they do. Right now, weird, challenging, puzzling time. There have been weird, challenging, puzzling times in the past.
Right.
Now, I'm not going to minimize at all what's happening now, But when I graduated from Queen's University in 1984 with my law degree, I ended up going to grad school. But most of my colleagues were going into the practice of law. And that was an era when there were 20% interest rates.
Right.
And, to the extent you had debt, it was really getting higher just from the interest rates. And we graduated into one of the worst recessions since the 1930s. I mean, back then there were three large car makers that really mattered to the US and Canadian economy. And Chrysler went bankrupt. Ooh. And, the whole economy kind of quivered. And then all of a sudden, like sacrificial lambs, we all graduated into the market with this debt. So, times, every generation has its challenge, and I'm not going to minimize this one now. The point is obvious, though. As Her Majesty the Queen said, at times will get better. We will meet again.
Yeah.
Live in the fourth dimension. Things will get better. I think, remember this, that we'll get to more practical advice, I think, shortly, but also at the general level, just remember that we remain a society ruled by law.
Right.
As long as that's the case, there'll be a need for lawyers, because there'll be law. In light of this pandemic, lots of new regulatory law. The number of lawyers will always be increasing.
Right.
So, for better or for worse,
right.
We're all going to be needed for a while.
Right. Let me ask you a bit of a follow-up to that, because I think there's a specific class of lawyers, of new lawyers, articling students, who some of whom have lost the opportunity to have an articling position, some of whom have lost the opportunity to have an associate position. Very tragic stuff, actually. Yeah. What do you have specific advice for that group of people? Because I'm sure there's a few people like that on this call today that would appreciate your thoughts on that topic.
I'm an optimist generally.
Yeah.
And it will get better. As a matter of fact, I think to some extent there's pent-up demand for lawyer services. I think there are a lot of consumers of legal services, both in the public and private sector, who have put off decisions, put off things that they have to do, just because of the uncertainty of the current climate. This will end, and when it ends, everything will have to be done that should have been done long ago.
Right.
Including everything that has to be done right now. So there's pent-up demand, and I'm expecting that not only will everyone, if they're capable, be hired, but I suspect the next complaint might be they're too darn busy.
Yeah.
And I think we all know now that's a very good problem.
Right. Just about to say that. Good problem to have. Yeah. So you touched on some of the adversity you faced.
Yeah.
Growing out of getting into your career, and you went to grad school, but the economics for your graduating class weren't ideal. Is there any other advice from your own personal experience of adversity that you faced in your own career and how you dealt with it? Some of that advice might be applicable to people that are going through this very problem today.
Yeah, let me get personal for a moment. After grad school and a clerkship, I joined a large Bay Street firm. And when you join any organization, large or small, when you join it for the first time, you are at the bottom of the hierarchy. And what comes with that is all the stresses and annoyances of being at the bottom of the hierarchy. Right. And there again, fourth dimension time, you just have to go through that because ultimately there will be a time that you're running projects or files or having the main decision-making say. That comes with its own problems, I might add. So keep that fourth dimension of time in mind. Speaking very personally, I would say, and it's not at all an insult to the firm I joined. I think many people feel this way, but after 2 years, working so hard to get up the learning curve, doing things for the first time, working with clients, large and small, difficult and easy for the first time, facing the incredibly difficult deadlines of everything, dealing with hierarchy, dealing with the miscommunications and political things that can happen in offices. I really felt like quitting after 2 years.
Wow.
And I think, the people I speak to, former students, former clerks, sometimes feel that way too.
Yeah.
Just wait that out.
Oh,
it does get better. Believe me, if this conversation, Mark, is saved to YouTube, someone can watch this 5 years from now and criticize the heck out of me if it turned out what I just said is wrong. It really does get better.
Yeah.
So be patient, tough it out, keep your emotional maturity. It really does get better.
Well, let's get into maybe some of the practical ways we can make it better as individuals and as participants in this legal community. So in your view, what are some sort of practical tips and tricks that you've come up with over the years to lead to a survival and thriving in the legal profession?
Sure. Let me deal with it this way, Mark, if I might. I'm going to talk about things to avoid. I'll call them, everyone should imagine they're a ship. I'm going to be describing the icebergs that people should avoid. And then I'd like to talk, instead of negatively, I'd like to talk more positively about what people might try out to make their way to survive. But more than survive, you want to thrive in the practice of law, whether you're in private sector, public sector, even the academic world, what have you. Let's talk about the icebergs. First of all, the first iceberg I want to mention, and it's tragic because I see so many great people hit this iceberg and sink. It's a concept I call plateauing. And sadly, some of the most talented people in law school, the ones that win the big giant clerkships, the ones that have the gold medal from their law school, a number of them really founder on this iceberg and sink. Plateauing is the concept that consciously or unconsciously you think you've made it. And so consciously or unconsciously you stop growing and developing as a person and as a professional. If you think about it for a sec from your own lives, there were classmates in high school who didn't give a damn anymore about school, and they thought they had learned all they needed to learn, and they left before graduation in high school. Others graduated and same thing. They thought they had everything they wanted to have, and that's fine. That's a choice. But I feel sorry for the ones that actually might have done something different.
Right.
Then, there's the people in university, and there's people that get their law school acceptance, they get into law school, and then they just kind of float in law school and not really take advantage of the opportunities it gives. Then there's others who get their articling job, and they're hired back, then they just plateau. They kind of think they're good. Then you see some who are associate lawyers and they get admitted to partnerships, or within the government they achieve a certain level of promotion, and then they plateau and they don't really grow further as a person or as a professional. You see where I'm going?
Yeah.
I think the aim in life, regardless of your station, is to continue to develop as a person and a professional. The job of being a student never stops. And if you think of the best people around you, the people that inspire you, that's how they roll. They never plateau. So that's the first. That's the first iceberg. I think another iceberg, I'll be shorter with a number of them. These days, people talk of work-life balance. For some, that's an iceberg, because work-life balance becomes a half commitment to your work and a half commitment to your family and personal life. The most successful people I know, their work balance is like 110% work and 110% personal.
Yeah.
Like they're incredibly effective personal people,
Yeah.
professional people. So if you're thinking of work-life balance, think of it that way. Don't founder on the sort of, there's only so many hours in the day, so I'm going to be mediocre at both. Another iceberg, particularly in the private sector, you're encouraged to market as a young professional.
Yeah.
That can be an iceberg, and you start concentrating on what I call wrong marketing. I don't think you can market until you have something to sell. So the key, and we'll talk more about this in a moment, is to learn your craft. Another iceberg, this is huge, especially for your generation. In my generation, I didn't have internet. I didn't have text. I didn't have all the wonderful gossip through email to distract me. Your generation has so many distractions, and I do now too. Technology is a curse. Good time management is essential. Bad time management is an iceberg. You have to be very conscious. Try a logbook for a week and just write down all the times your time leaked into activities that may have been entertaining but not particularly productive.
You're right.
Bad time management is a killer. Here's another, and it's related to bad time management. I like social media, sort of lurking and watching it. But I think social media is an iceberg. I've seen it give some people the temptation of celebrity and instigating change, but kind of pointless change. For some people, they read stuff, they think about it, and then they just do a like, and they think they're accomplishing something by doing a like or doing a retweet. If I could draw on a cultural thing, I'm a Star Trek fan, and Star Trek: The Next Generation. If this resonates for anyone, maybe it will be helpful. They had a holodeck, sort of this recreation room where people could go and live out an illusion. I think Twitter is a holodeck where people get to go and act out a life, and it's tremendously entertaining, perhaps fulfilling, but my question would be, what are you really accomplishing?
Yeah.
And it's a bit of a leakage of time. And the other thing is, you are making or breaking your reputation. Most are breaking their reputation.
Yeah.
So be careful. Next iceberg. Watch your physical and mental health. It's ruinous. Many of you are young, and you kind of think you're immortal, and you live like you're immortal. You're not. I wish I could speak to my 20-year-old self. You got to learn to eat right. You got to work out, because when you hit your 50s, and certainly in your 60s, you start to break down, and that's no fun.
Right. Yeah.
You want to put off that day. If you're going to do good for your family, for your world, for your organization, you have to be in good health, mental and physical. Next iceberg. Think of this fourth dimension of time and understand that your life is going to unfold, but it doesn't unfold in a linear, predictable way. Life's full of the craziest eddies and currents, and you'll be buffeted about. I've sometimes used the analogy of being on a sailboat far out in the ocean with no shoreline, no islands, and the wind is blowing you. I encourage you to have your hand firmly on the rudder and steer in some direction, but you're going to be blown about. And as you see islands, visit them. Maybe they're good places to spend some time. But sooner or later, you're going to come ashore and you're going to live there. But until then, be a little flexible, but keep your drive and direction. I think the best thing you can do to avoid icebergs is skills development. Do you want me to go there?
Yeah, let's flesh that out a bit in terms of what that
Okay,
means.
well, that's the positive side. I just gave all the negative things to avoid. I think more important are the positive things. And again, I'm speaking here to the young professional. The most important thing is to learn your craft. The start of your career is the best time, and in some cases the only time, to really learn your craft. And on this, two big thoughts. Cultivate mentors. I had great mentors. And you cultivate them by, if a senior person comes into your life and gives you a little bit of training and guidance, go back to that person. And that person will be encouraged to give you even more guidance. And over time, a friendship and a mentorship develops. That person will impart incredible amounts of wisdom, not just knowledge about how to do things, but wisdom and judgment about how to handle the thorny situations that arise. The other thing, when I say learn your craft, is, for goodness sakes, learn to write. We don't really deal with clients or superiors in the office or in departments of justice or attorney general departments, client departments. You don't really deal with them in person anymore. It's in writing. You don't really deal with courts very much in person anymore. It's in writing. For goodness sakes, learn to write. Write well. Not only will you win a lot, certainly a lot more than if you wrote badly, but writing is portable. People circulate with Control F in email. They circulate your writing. You want to become known? Forget about Twitter and what you think, whether you're liking something or retweeting something or expressing some view on something. Forget about that. Learn to do your craft and write it up brilliantly and well. That will be your calling card. That will be your reputation. In my era, when I started out, dressing nice was really important because there were so many in-person meetings. And, if you wanted a professional to be regarded as a good professional, dressing the part was really important. That's still the case. But I would suggest to you that writing well has overtaken that by a long shot. Second big thing is learn people skills. And here I wish I were speaking to my 20-year-old self, because I wasn't that great with people when I started out. I tended to be a little impatient and opinionated. Over the years, I've learned a lot more about the value of listening and considering. I've learned about the fourth dimension of time, that sometimes the best response in dealing with a person is not to react right away, but react later in time. That's sometimes very wise. Learn to deal with people at all levels. For people who are going to be serving clients, client service is everything, and it's what your profession is about. It's not about you. It's not about wealth maximization. It's not about the health of your organization. It's first and foremost serving your clients and serving them well. Law is a service profession, and you've got to learn to serve. People retain and keep lawyers they like and lawyers that they know will serve them well. And on this, this is where mentors and teachers in your life will really train you. That really matters. They will teach you people skills. Watch more senior people in a difficult situation or in a meeting. Ask them later why they did certain things they did and why you thought it was effective, and let them talk and listen to them. And in meetings that go wrong, particularly if the other side misbehaves, ask for a moment to deconstruct it. Why do you think they were so ineffective? And, learn about meetings and how to handle people in that way. One bit of wisdom I can give that I wish I could give to my 20-year-old self is, though overall, the world is a mirror. If you're going to be a jerk, you're going to be grouchy. If you're going to be impatient, you know what? That's how the world's going to be back to you. And I learned that only too late. Fortunately, I learned it in time.
Yeah.
Lastly, I think it's really important, whether you're public or private service lawyer, to engage in market differentiation. You want to be a go-to person. You don't want to be fungible. And I'll tell you one way, if you're academically inclined or your specialty is knowing law, it's really to keep current. Most lawyers, in fact, don't keep current. They graduate from law school with most of the law they'll ever know.
Right.
By keeping current, you are differentiating yourself and becoming an answers person. Let me tell you what I did. It was hugely effective. Friday in the office was always kind of a lighter day than the rest of the week. Sometimes people would take a day off on a Friday, which means fewer client calls, fewer people in the office wanting to see me. It was generally just quiet, and people are looking forward to the weekend, so people ease off a bit off the gas pedal. So what I did is, first thing in the morning, I would come in early on a Friday, sometimes as early as 6 or 7 in the morning. I would spend 3 hours doing nothing but reading law and taking notes. And I would prowl later in my career the court websites and reading the new law. And it's funny, you start to remember things you read. And I'd find myself in meetings with people or dealing with clients, and they'd have a problem, and they'd say, you know what? Something was just written about that. Let me get back to you. And I think it's perfect. I think it gives you the answer you need. Or another situation would be, I think there's now an opening here that we could try in litigation. It wasn't available a month ago, but I read something recently. Let me get back to you. And that opening turns out to be something that someone else wouldn't have seen. And I've, in effect, created billable hours. If you're into that as a private sector lawyer, you find a solution. Obviously, it has to be worked up. You've just created a file. But the real reason is to serve your clients better and to differentiate yourself in the market. So I used to analogize this to working out in a gym, which sadly I never did, and I wish I did, because things are breaking down for me now. But this is intellectual workout.
Right.
Once a week, I say on a Friday morning, and just read law, statutory law about new things and interesting things from decisions. When it was on the web, it was really easy. And what I used to download were the things that took, what I used to pay attention to were things that took a long time to download, because chances are, if it's long, it's complex and it's interesting.
Right.
And the judge is doing a lot of justification because something interesting has happened.
Yeah.
So, others that, took a millisecond to download, I would just kill and move on to the next, because, they're just from the bench and probably uninteresting. Yeah. So that's a very practical tip for people. But the key is to differentiate yourself. You do not want to be a fungible lawyer.
Right.
Another way of not being fungible is actually a little later, when you've learned your craft and you have something to share, to speak at conferences, to volunteer, to get your name out there, to speak at conferences, or to do conference papers, and perhaps on Twitter, give a link without comment to your conference papers so people read and enjoy it. That's how reputations are built.
And that would be a good use of Twitter as opposed to just the holodeck use. Yeah.
Well, yeah. Don't use it as a holodeck. Don't use it as a recreation room.
Yeah.
Use it as a functional work tool, knowing always that you are being watched. And reputations can be enhanced but more often than not, they are ruined.
Mm. Well, let's conclude maybe with a final question.
Sure.
And I think this goes into a reputational thing as well. There are probably lots of people, lots of law students and young lawyers who have designs on being a judge one day. And I guess, to answer their question, how do you be a judge? How do you become a judge in your experience?
Okay. We have an appointment system, and I won't describe it in great detail, except to say this. The rubber hits the road in the appointment system at the level of gossip.
Mm.
Is candidate X going to be a good judge or not? And most people who are considered for appointment, the statute says minimum 10 years at the bar before you're a Superior Court judge. De facto, it's really 15 years, 20 years or more. And after that period of time, there will be rumors about you, knowledge about you, scuttlebutt about you. And I think if the scuttlebutt is widely bad or narrowly bad, but really bad, even to the point of one person who's trusted by the appointment authority thinking you are really not suitable, then you will not be appointed.
Mm.
And so everything I've talked about, learning your craft, differentiating yourself, this all plays a role in creating good reputation, good scuttlebutt about who you are. I think if you're going to be a judge, your first instance or appeal, the scuttlebutt about you has to be that you as a person are a fair and tolerant person.
Yeah.
And also a person who loves law. I think people, this is where law geeks finally get their due. If you're a law geek, then, you've satisfied, I think, the biggest or one of the big qualifications of being a judge. So you can't just wake up at the age of 52 and say, I'm going to be a judge. I think in advance, you have to be mindful of the fourth dimension of time, that down the road, this might be a possibility. And so manage your reputation. Let me talk ever so briefly about private sector law or public sector law, where you're dealing with an adversary on the other side. I am not saying roll over and give them everything they want and be the Mr. Rogers of law and be smiley and pleasant and all of that. No. You have clients to serve. Your job is to serve your clients firmly, to advance under rules of professional conduct, advance their interests vigorously and fearlessly. That's your job. And everyone will give you credit for that. It's just learn the marks of a civil professional. A lawyer on the other side, their child has a sudden illness which requires the lawyer to stay at home, and it's really unforeseen, or let's say child in the hospital, or another really strong extenuating cause, or a very extenuating cause for the client on the other side. Be fair. Give them the adjournment. You might hold their feet to the fire and say, but I want dates from you by tomorrow, or I want this discovery to take place within a couple weeks, and I hope you'll accommodate me on that. That's an example of being firm, representing your client, but at the same time, just being a good, fair professional. And what goes around comes around.
Right.
The world is a mirror.
Right.
Deny that adjournment, it's going to happen to you, guaranteed. And everyone will know about what you did. The legal world is a very small place.
Small place.
Reputations spread, don't they?
Yeah.
They really do. The interesting thing about reputations and gossip generally is really salacious, bad gossip spreads really effectively and really badly.
Right.
Like wow. So be careful.
It's what they say about reputations. Difficult to build, easy to lose.
So true.
Yeah.
Be careful.
And these days,
represent your client, though. I can't emphasize that enough. You've got a job to do, and people will give you credit for doing that job.
That's great. Well, that's our final question. So we have about 15 minutes, I think, for audience questions. I haven't seen any yet. So if anyone has a question, please type in the chat box or let us know by raising your hand, and I can allow you to speak verbally. Let's see if anyone has any.
I'll take any questions from you, Mark, in the meantime, if you have any.
Yeah. Well, let's keep it going then in the meantime. So in terms of career and younger lawyers, I think one challenge that people are having right now, right in this particular moment, is just we do have one question. So maybe let's get to the audience question.
Okay, sure.
Yeah.
Wonderful.
Okay, somebody has a question. Okay. You can. It's from Gordon Tennant, who is one of our Lakehead chapter leaders, Runnymede chapter leaders. So Gordon, you can.
I'll get this way, Gordon.
Okay, so he says, can you talk a bit about how you see the role of public interest intervenors in the federal court system?
Right. I have I've written about that. Public interest litigants, I consider myself bound by the very good decision of the Supreme Court of Canada written by Justice Cromwell in Vancouver East Side. But you said public interest intervenors,
right?
And that's a different issue. That's in our court intervention under Rule 109. The parties to the proceeding are up and running, and someone else, a third party, often a special interest group, wants to participate. In every court is different, and that's the first thing to recognize. So read the rule of the court you're acting under. In our court, Rule 109 requires a party to establish a different perspective that's not already on the table in our courtroom, and they have to contribute something useful to the determination of the issue. We take that requirement really, really seriously. And so to give some examples, in a case where, in my view, issues of equality rights of women were not an issue, I denied the right of a group committed to equality rights for women to intervene, simply on the basis that nothing they presented in their submissions would help advance the court's ability to determine the precise legal the precise legal issue before it. We sometimes get interveners who want to speak to us about international law, but unless international law is legally relevant to the issue before us, we're not going to invite that person in. Putting it positively, though, where an intervener is truly taking an issue that's already on the table before us and saying, oh, I have a different perspective, and my perspective will help you decide this on the law. And we look at it and we look at the legal rule and we say, yeah, that perspective could actually help us. We let them in.
Mm.
So think of it as, this isn't the best metaphor, but think of it as a gate to a club. with a very fussy bouncer that's, checking all the IDs. But once you're in, you're going to have a good time.
Yeah.
But you got to first establish that you should come in. That's unlike some courts. The Supreme Court of Canada, and I've written about this, the Supreme Court of Canada seems to let everybody in. One of the issues that I've written about in contradistinction to the Supreme Court of Canada is I'm very mindful of a concept called equality of arms. So if we've got 10 people applying to intervene and 10 of them are on the side of the appellant and none of them are on the side of the respondent, I'm not going to allow all 10 in, I'll tell you right now, because it then becomes a gang up. And it isn't just the reality of a gang up, it's the appearance of a gang up. An appearance of fairness is very important. And I don't want to be accused of a court-sanctioned gang up, 10 against 1. That just looks really, really bad. And I have very strong views about that. So I will take the best of the interveners and allow, there's no particular number, it all depends, but I might only allow 2 or 3 in.
Okay, well, we have some more questions. So Gerard Kennedy wants to speak, so I'm going to allow Gerard to ask a question here.
Oh, good.
So Gerard, you're on.
All right. Thank you, Mark. Thank you, Justice Stratis.
Hi, Professor Kennedy. How's Manitoba?
It's very good. We are almost COVID-free and opening up, which is a lovely place to be.
Well, Professor Kennedy, I have friends in Winnipeg, and they've been boasting about patio beers and so on. And in Ontario, starting tomorrow, we have patio beers. So I'm not going to visit you. I can stay at home now, but
I hope
it's nice to see normalcy.
It is indeed. I was delighted to be able to actually go to a patio last weekend, and it was nice. So I'm glad it's
don't
coming.
rub it in. Don't rub it in.
Well, in a few days, it'll be in Ottawa once more. My question really is about how you conceptualize the inherent jurisdiction of statutory courts such as yours.
Yeah.
Particularly now that we are in this time where courts really have to try to accommodate exceptional circumstances on the fly,
right.
And how you try to reconcile inherent jurisdiction that perhaps the judges have with, I guess, the statutory language of the courts. And I know this isn't before the Ontario Court of Appeals, so I don't wish you to comment on that in particular, but how at a broad level do you try to reconcile the fact that we're in an emergency situation right now with the fact that there are statutory constraints on courts such as yours?
Great question. Professor Kennedy, at the outset, I'd like to compliment you. Not many people in the Academy are interested in practice and procedure, and you are beginning to mark yourself as a specialist and a keen observer, and I just think that's terrific. I, too, have a huge interest in practice and procedure and have written much on it. To that end, let me say a couple of things. There's a dig against statutory courts. Sometimes we get it from the Supreme Court of Canada. I've written an article in the University of New Brunswick on this very topic, discussing the differences between statutory courts and courts with inherent jurisdiction like superior courts. The article title is "A Judiciary Cleaved: The Illogic of Difference Between Statutory Courts and Courts of Inherent Jurisdiction." So I would commend you to that article for the more detailed academic response to your question. In brief, it's this. Statutory courts, their powers are set out by statute. Guess what? Modern superior courts, their powers are set out by statute too. The inherent jurisdiction of superior courts is only a subject matter inherent jurisdiction. If a subject matter has not been assigned to any court, the superior court by default has it. That's their inherent jurisdiction. But at the statutory court level, which would be federal courts and many provincial criminal courts, the fact that a statute calls us a court, and the fact that constitutionally we enjoy the judicature guarantees under Section 96 to 101 of the Constitution Act 1982 means we interpret our powers as a court. We aren't an administrative tribunal that's been given statutory powers. We aren't a delegate of a minister that's been given statutory powers. We're called a court. So we have a wide array of penumbral powers. I call them plenary powers that allow us to regulate various matters. If you want a summary of those in the federal court, I have really run with that concept. So if in Canley you type in the text field Stratis and plenary, you'll come up with just just an armful of decisions. Now to the pandemic. If you look at the Chief Justice's first order that regulated what we're going to do on the pandemic, it was back in March, I believe. In that order, the Chief Justice set out the basis for the order, and he set out two bases for the order. One was our plenary powers. The other basis, though, is that if you look at our rules of if you look at our rules of court, certain rules allow us to depart from rules in special circumstances. Rules 53, 54, and 55 in particular. And if there was ever a circumstance that's a special circumstance, this was it. And so the Chief Justice was able to enact basically a pandemic procedural code and threw out a lot of the rules of court. And it's both our plenary powers and rules 53 to 55 that allowed him to do that. Sorry for the long answer, but I'm a practice and procedure geek like you, so you'll understand.
It was a good answer. Thank you very much.
Mark, have we lost our audience after that long-winded? I can't hear you. You're muted, Mark?
My apologies. Okay, we haven't lost the audience.
Excellent.
Still here. Here we have a question from Bruce Party, who has a question that I think is going to be very relevant for students. Can you give us your top 5 suggestions for how to become a great writer?
Oh, terrific, Professor Party, and greetings. Can I boil it down to 3?
Sure. Yes.
I don't think there's 5.
Yeah.
I'll give you 3 things you might do in your writing, and then an overall. No, let's make it 5. Let's make it 5. Okay, my first is a big picture comment. I want you all to implement a style of writing called point first or context before detail. That means say what you're trying to develop, say your conclusion up front. And you do that not just at the start of your document, but you do it all the way through, so that your reader knows exactly what you're dealing with and why you're dealing with it. That's an big overarching issue. The next 3 tips are at the sentence level. I am a real believer that if you construct a clear, direct, and brief sentence, you can't go wrong, even if you ignore all the other rules of writing. Clear, direct, and brief writing just yields so many dividends. Here's the first tip. I want you to avoid wimpy words. Wimpy words, particularly the verbs. And the biggest wimp of all is the verb to be. Is, was, were, be, being, becoming, became. That verb is just what a mushroom does. It just exists. If you go through your sentences and you try to edit to take out the verb to be, you'll get rid of what writers call passive voice and nominalization. Nominalization is where you take a very active, flavorful verb and turn it into a lifeless being. So instead of, the board decided to fire the chief executive, It's the board made a decision to fire. Made is such a wimpy word. Get rid of it. Default to these strong active verbs. And in getting rid of wimps, you'll find you're using fewer words. So use one word if you can. Instead of made a decision, decide. Other forms of wimps are what I call throat-clearing phrases. Now, having developed blah, 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 I am now going to develop blah, blah, blah. And then you say blah, blah, blah. Just say blah, blah, blah. You don't need that wind-up. Just make the pitch. Another example is what I call throat-clearing phrases. It is important to note that the dog bit the man. Well, that sentence, actually means the dog hit the man. That's why I call it a throat-clearing phrase. All those words didn't mean anything. Of course it's important because you're saying them. You're writing them. So you don't have to note their importance. Last tip is to manage the connection between sentences. You want to connect concepts and words. You want to glue your sentences together. You know that relay in the Olympics with the baton? I have my little baton in my hand here. You know, the one with the 4 runners and they all pass the baton to each other. And I always marvel at not only how fast the race is, but how seamlessly the baton gets passed from runner to runner. That's how your prose should be. And the way that works is this third tip of passing the baton, of connecting your sentences and gluing them together with nice connectives, however, therefore, on the other hand, and so on. I think if you want to see these 3 tips in operation, if there's a particular paragraph, say of mine, that you like, go to the paragraph and reverse engineer it. Look at the verbs I've chosen. Look at the economy of wording, how I've tried to strip fat out. Like, actually look critically. Maybe you can find fat and write and tell me and say, Stratis, you didn't need to say blah, blah, blah in paragraph, blah, blah, blah. But I think you'll find I'm pretty lean. And lastly, and most importantly, look at my connectives between sentences. Look how carefully I take care to glue them together, literally and conceptually. The 5th overall tip is practice, practice, practice. You never become a good writer. You're always becoming a good writer. You've never arrived. I look at the stuff I wrote. Some people say I'm a good writer. I don't know, Patty. I look at the stuff I wrote 5 years ago and I go, you know, people cite me stuff in court and you look at it, that, you know, stuff I've written, I go, whoa, I really wrote it up that way? You get better and better and better and better. Which brings me to my first comment. Never plateau. Always be the student. And as a professional writer, you want to always be the student of writing. Learning, getting better and better. If you read something and you like it, reverse engineer. Ask yourself critically, why did that work? And then try to emulate it in your own work. Here, mentors and teachers are great. There's some great writing courses, enroll in them. There's some great writing books, buy them.
That's great advice. I think that's very useful to all the students that are listening in. I think we've been going for about an hour and 20 minutes, so perhaps we'll make this the last question.
Okay.
Just to keep your time safe, Justice Stratis. But this is a question from Diane, who's actually one of our chapter leaders at the University of Ottawa.
Okay.
And her question is, I'm wondering if you think people will have a choice in the future between having an online or in-person hearing. And she's thinking from an access to justice perspective, since there are people who may not have the means to attend a hearing or other kinds of difficulties, there might be this option. So maybe you could comment on that, Justice Stratis.
Sure. Brief answer only is needed. So maybe we can take another. If
okay, sure.
We have had that option in place since late 80s. Video conference or in-person hearing. And I would say in my career, the proportion of video conferences to hearings generally is 0.003%. Where people have a choice. So the quick answer is, in the federal court system, you will always have the choice. You've had that choice. But the remarkable thing is how few people actually opt for it. Normally, the only people who opt for it are people in confinement, like inmates in penitentiaries, and they're kind of forced to opt for it. But interesting thing for us to see will be post-pandemic, will people actually opt for it? We'll see. But the option, it's available.
Okay. Well, that's very interesting. Okay, great.
It comes back, Mark, to this idea that in-person hearings, people want to see the judges.
Right.
They want to confront the judges. They want to speak truth to power and not have the intermediary of a screen and a camera.
Right. Okay, we can take another one. So this is about this. I think goes to the access to justice point. So I think it's relevant. So we have a question. The federal court has been developing its class action jurisprudence, often with your leadership in the past few years. Where do you see the court going in the coming years towards filling the vacuum for a national forum that deals with national class actions?
Interesting question, and it's one that I have to be careful about.
Right. Yes.
Because the issue of where a class action should be litigated is a policy decision to be worked out among different levels of government in conversation with the bar and other stakeholders. And that's kind of when you think about the separation of powers and how, my view is we should all stay in our lane. I think that is very much in the legislative and executive lanes and not for us to decide. Another reason for me to avoid it is there's a legal issue there about the jurisdiction of the federal courts and also whether the federal government could, even at the level of division of powers, legislatively enact such a thing. It would be a battle between perhaps national concern versus property and civil rights in the province. And that's something that could be litigated one day, including in my court.
Right.
And so it's best that I not talk about it. But I certainly understand the question where it's coming from, and it's an interesting issue to be sure.
So shall we call it there, perhaps, to save your time, Justice Stratis?
I'm flexible. It's up to you.
Okay. Well, we do have one last question, but I think you may have to avoid this as well. But I'll ask it.
Okay.
I'll ask it. Just doing my part as the moderator. Do you have any comments on the Ontario Court of Appeals holding regarding horizontal stare decisis in Sullivan and Chan? Yeah.
Yeah. If the Supreme Court of Canada were to take it, it's still in the litigation pipeline, and even at the best of times, it's probably best that I not comment on it. It's a very live issue. And it's a live issue that happens to arise in a very complex, difficult, and socially difficult context. So that's one that I'm going to avoid.
Yes.
I'll make a comment by way of general guidance on that issue. Every court in the country, every jurisdiction has rules about horizontal stare decisis, and they are not uniform. And I know that our court, including one judgment by me in the area of patents, we speak to this issue. We also speak to the issue in my court about when one panel can disobey another. And we have a really important case from 2002 called Miller. And so if you're litigating in our court and you don't like a particular case, well, too bad, we're bound by it, unless we use it as a verb, unless you can Miller us and say that panel committed what we call manifest error. And manifest error is defined in Miller. So underneath this very interesting question that I can't answer
Yeah.
is actually a really important practical issue of when one judge binds another judge in her or his own court. And my advice is in every court to look at that court's rules, because there is some commonality, but there are also some subtle but also sometimes significant differences. Different courts do different things.
Well, that
These are
actually,
smart questions.
yes, I'm
Sorry,
very,
I can't get into them.
yeah, very interesting questions that that are going to be topics of conversation going forward, I think. So that actually exhausts all the questions we had. I thought they were all great questions.
Yes, indeed. I never cease to be amazed, both in my part-time teaching activities and speaking at conferences and going to Runnymede events and the events of other organizations and speaking to young professionals and students. The next generation, our society's in for a really good time. I'm so impressed by the level of learning and the calibration of values of today's young. And there's a sense in which the faster we leave this stage, the better. So kudos to all of you. Keep up the great work.
That's great.
And do us proud. When I'm in the old age home, I want to read all about you.
I can just only second those comments as as Runnymede Society Director. It's just such a pleasure working with students who are just so bright and seem to be getting brighter by the year. So it's just a real pleasure. So Justice Stratis, thank you so much for this today. I think everybody learned a lot. Really important discussions and topics. We're just so happy to have you here. So thank you again.
My pleasure. Thank you.
For those interested, next week we're also going to have Justice Lauren Sawson next Thursday at noon Eastern to discuss the question of whether justice has gone viral. So please register for that. You can find that on our Runnymede Twitter page. You can find the registration link, and we hope to see you there. Thank you very much again, Justice Stratis, and for everyone for attending. Thank you. Have a good day, everyone.